CR335. This is Jefferson Capital System versus CR336. Matter is before the court on the filing of a motion for dismissal. The record should reflect that the court entered a previous order in this matter regarding trial scheduling. One moment. For the plaintiff, your appearance at this time.
Good morning, Your Honor. Attorney Ashley Nonis, P77029 on behalf of plaintiff.
All right, thank you. Good morning to you, Ms. Norris. For the defendant, do I have Ms. Troop here or someone representing Ms. Troop? If so, say something at this time.
This is Sarah Troop, myself.
Thank you, Ms. Troop. Good morning to you, ma'am.
Good morning.
And counsel, update me on the status of things. I do see there is a motion for dismissal regarding this matter. Counsel.
So we never received any motion for dismissal. However, we never received answers to our discovery request. Therefore, everything is deemed admitted. So I would actually ask for you to deny the motion to dismiss, which I don't even know what grounds, as I stated, she has, because we never received a copy, and actually provide us time to file a motion for summary due to her failure to respond. And under the court rules, everything is deemed admitted in this matter.
All right. What I do have, I think that there may have been a failure of service or something in regard to this. I have a set of interrogatories that have answers marked out on the interrogatories. Let me ask you, Ms. Troop, did you send your answers to the interrogatories to the plaintiff in this matter?
I apologize, Your Honor. I read that wrong. I thought I was just filing it with the courts. I apologize.
Well,
I thought I was doing it. I filed it with the courts, and I was I thought I did that. I'm sorry. I read that wrong. I must have read the directions wrong.
All right. All right. Thank you, ma'am. So I do have the answers, and the rules require that they be served on the defendant. I'll allow those answers to be turned over to the plaintiff in this matter. In fact, it looks like you sent the originals to me. Did you make a copy of them at all? Sorry.
I did not, Your Honor. I apologize.
All right, so we'll get a copy out. The motion to dismiss is a document. Of course, you didn't send that to Jefferson Capital either. You sent it to the court, correct?
Yes, I filed everything with the courts.
It says in the reason for the request, Madam Counsel, it says the account provided by the plaintiff does not belong to the defendant. Unknown merchandise. It says C Exhibit A. And it says plaintiff bill of sale dated January 13th exceeds statute of limitations. And then there is looks like the Exhibit A in this matter seems to be, well, I'm not sure what the Exhibit A would be. I suppose that you were offering your answers to the interrogatories as Exhibit A. Is that what you're saying?
It was their exhibit, and I was just showing that with their own documents. It says it was dated January 2013, which would exceed the statute. That's what I was looking at that part.
All right. So there's an exhibit that was attached to this particular document, Madam Counsel, that is actually Exhibit F under your under some documentation that was received indicating a bill of sale of the original creditor to WebBank, and it has a date of January 10, 2013, and it indicates a transfer of obligations or rights in that document. This is the nature of the motion to dismiss with regard to this matter. And I know that you don't have those items, Madam Counsel. Anything you wanted to say at this time?
Well, Your Honor, based on the documentation we have, the last payment she made on the account was 2016. So a statute of limitations defense wouldn't apply. I would ask that if the court can send us the motion, send us whatever answer she sent to the court, and provide us time to file a motion for summary disposition. I think the court will easily resolve this upon our motion.
All right, well, it certainly looks like a situation that that needs to be at a minimum reset. When is the last time that you, to your knowledge, the best of your knowledge, ma'am, when's the last time you made any payments regarding this matter?
I believe that Finger Hut made an error and was charging me on someone else's account. If in 2013, when it was charged off according to their exhibit, then I wouldn't have an active account being able to pay in 2016. So I definitely had, I've moved twice since then, but if it was 2013 when the charge off, then how did I make payments in 2000? As they claim in 16 and 18, I have what they have, they're saying merchandise in 2018. It was not my account. I spoke with Finger Hut and I had a zero balance when I stopped dealing, stopped dealing with Finger Hut.
Okay. Your Honor, before we keep arguing.
Counsel, I'm coming back to you. Ms. True, were you finished?
Yes, I was just saying when I hadn't dealt with Finger Hut in over 8 years, and I don't have yet. I think I was done, Your Honor. I'm sorry. I was just rambling at this point.
All right, thank you, Ms. Morris. Ms. Norris, I'm sorry.
Sure. I mean, now's not the time and place. Obviously, the court's going to adjourn this to argue the case. So as I've stated, I would ask that the court adjourn this matter, send us the documentation that she allegedly filed, and we will file a response to her dismissal motion as well as filing an MSD. I think the defendant's a little confused on the facts and circumstances of this case, and maybe once she sees that information, it might flush it out. And keeping in mind, per the court rules, even if she answered the interrogatories, she failed to answer the request to admit. So again, under the court rules, everything is deemed admitted. So her motion to dismiss should be denied already, but if the court's inclined to give time for that, I would ask for the time for the motion for the summary as well.
All right, I do not have a request to admit documents or answers. I've indicated to the respective parties what the court has received. And obviously, Ms. Troop, if you received a request to admit documents, you would have been required to answer them within the time permitted by law as well. But what I'm going to do is I'm going to make sure that the various documents get out to the plaintiff, those that have been sent to the court. And then I'm going to set a new date on this. It sounds like to me, you know, counsel said this is not date and time to argue certain issues. Ms. Norris, with all due respect, of course, that's my decision. And the point being that it seems to me that the issue with regard to statute of limitations is not likely going anywhere. I see a billing in 2018, et cetera. And it looks like there is a payment history where payments were made subsequent to the period of 2013. So it does not appear that there is much traction in that regard. But I'll wait to make a decision. The reason that I was allowing discussions on that issue is because it seems to me that in a complaint that is brought before the court that alleges, looks like to me, just 1 second here, that alleges damages of $1,290, that the parties probably need to look at a way of discussing this to see if we can reach a resolution, because it does not seem to be something that's going to be dismissed for some obvious statute of limitations problem, because it doesn't look like that type of problem exists. Charge-offs and stuff do not create that kind of problem. What really is the issue is when the account becomes stated, whether or not there has been ongoing notification of billing, and whether payments have been made anywhere in the interim and or applied to the account. So, you know, obviously, if there's something that's on all fours, the court would immediately react to that and try and figure out a way to grant some type of motion in that regard. The most reasonable thing at this point really seems like the parties need to talk about this. It is a debt that is from back a little ways. It also is a debt that has exchanged hands over time. There is interest that is accruing on the debt. And so it just makes sense to kind of talk about a way forward where something is paid, maybe compromise a bit, and then figure out a way to be done with this. Otherwise, I'll hear the motions and stuff, and it seems like at this point, if you, I can excuse the not sending the notices to Ms. Norris, Ms. Troop, as relates to the interrogatories, but you haven't responded to requests to admit. That's a pretty kind of serious kind of situation because you don't respond to those under the court rules, they're deemed to be admitted. And so that's a challenge. Here's what I would urge, and I'll take a moment as I move on. I'm going to set a new date, but I'm hoping that you might be able to get to the bottom line on this today. I'll set that date about 45 days out because that gives time to file motions and all of that kind of stuff. I don't like for cases to drag on, but we'll get documents mailed out. But I'm going to put the two of you in a breakout room to see if you can get to some number that can resolve this case, because that's what really makes sense in this case, where there are too many moving parts. But if you can't, then of course, I'm going to give you a date. 5/23. That's going to be 5/23/22. That is a pretrial conference date and a motion hearing case, motion hearing date, I'm sorry. And any motion filed before me can be set for hearing on that date, as long as you give the other party at least 10 days to respond to the motion. So that's how I'm going to set that up. Again, I urge you to see if you can reach some conclusion on this matter in the breakout room, because it does not seem like this is something that that should be having all of this intrigue. And moreover, with the request to admit, that may itself be problematic for Ms. Troop, because she didn't file responses to the request to admit. But in any event, without making any decisions, I'm sending you a notification now. If you're able to get some resolve, then come back in and we can put that on the record and go forward. Otherwise, the date that I've given you is May 23rd, 2022, and that's going to be at 9:45 a.m. 9:45 a.m. 5/23/22. All right, you receive your notification. Take a moment to try and file forward on this. All right, good day to the two of you. All right, I am calling case number 21-169-897. This is Tox Testing Lab versus City of Detroit. The matter is before the court, set on for a pretrial conference date. I had a notation. I was awaiting an order of dismissal or something along those lines. Your appearance for Tox Testing, please.
Good morning, Your Honor. Michelle Khan appearing on behalf of the tox testing plaintiffs, P75585.
All right, thank you, Ms. Collins. Good morning to you. For the City of Detroit, ma'am.
Good morning, Your Honor. Mary Beth Cobbs, P40080, appearing on behalf of the defendant, City of Detroit. Your Honor, this was, I believe, the time and date set for the City of Detroit's motion for summary disposition.
Oh. I have something in the file with I have a note in the file that tells me something else. All right. But I do.
If I may, Your Honor, you may have been waiting for a order of dismissal for defendant Smart and the Michigan assigned claims.
There we go. All right, and I do have the motion for summary disposition. I'm looking to see whether I have response. Madam Counsel, did you file a response to the motion for summary disposition?
I did, Your Honor, and I had an email to the court the last time we had a pretrial hearing.
All right, I am not seeing that in file. Madam Counsel for City, go ahead with your motion at this time, Madam Counsel.
Yes, Your Honor, this was the city's motion for summary disposition based upon the fact that the city in this action had never, although this action was originally filed, Your Honor, in the 15th District Court. That was filed in July 3rd of 2021 for an accident which occurred March 2nd, 2020. Your Honor, this was subsequently transferred for a stipulated order to the 36th District Court. The dates of service involved in this action, Your Honor, are April 9th and April 20th of 2020. The City of Detroit, through an affidavit attached by our third-party administrator, Mr. Robert Russell, indicates that our third-party administrator, Comp 1, never received any of the bills prior to the attachment in this complaint that was not filed until July of 2021. And Your Honor, it's the city's position that the plaintiffs in this action their claims are barred by MCL 500.3145 as they failed to properly notify the city within 1 year of the date of service of these bills. We also had filed our motion, Your Honor, in addition to this issue on what supportive video from the bus video, Your Honor, that Mr. Gillenwater, the underlying patient in this matter, had not been injured to the extent that he alleges to sustain any injuries that would have required any services provided by these plaintiffs. And as well, we have a surveillance video which indicated also that this individual was never injured in this bus accident, which would sustain the services he claimed were necessary.
All right, so your two arguments is that any services provided to him, if there were any services provided, they were not necessary, and any injuries did not arise out of any accident involving a City of Detroit vehicle. And moreover, any submission of any documentation of injury or billing for services does not satisfy the 1 year back rule. Is it violative of the statute in such cases, correct?
That's correct, Your Honor.
All right, Madam Counsel, Ms. Khan.
Yes, Your Honor. So as to the first prong, so the only evidence defendant has is a grainy video that they attached to their motion for summary disposition. They don't have any medical records, any medical evidence, any expert testimony that stating that the patient was not injured in the motor vehicle accident. And as the court knows, obviously that is a issue that the patient's credibility and the patient's injuries are an issue for the jury. In regard to the second aspect, the second prong of defendant's motion, I will admit that I did request a copy of defendant's claims file. I did not see my client's bills in the claims file. I also did confirm with my clients that they only did have Michigan assigned claims as the proper defendant. So it does appear that the City of Detroit may not have been timely served with the bill. So I would leave that aspect in the court's discretion.
All right. So as I looked at this issue, it seemed to me that that challenge might have been one that was a little bit insurmountable under all the circumstances. And Ms. Kava, accordingly, as it relates to that particular prong of your motion, the motion will in fact be granted for some claims that relate to 1 year, beyond 1 year back. Those claims would be barred by the statute in such case provided. Moreover, I think that the issue with regard to whether or not there was an accident or whether or not the defendant was in fact injured in the accident, that's a fact question. That obviously what the plaintiff, right, the defendant has sought to do herein is to show that the circumstances are such that there is no way that the defendant could have been injured. That may very well be true to the extent that the plaintiff could be, to the extent that the plaintiff raises and alleges that as a factual issue, then some further proof would need to be provided, or further information would be needed to be provided to rebut the claim that there were injuries arising out of the use or operation of a motor vehicle that's in the vehicle. So on that part of the motion for summary disposition, which is prong 2, the court will deny the motion in that regard. But the motion is granted as it relates to the claims being barred by the 1 year back rule of the statute in such cases. I'll sign an order not inconsistent with the same. Now, let me ask a kind of a foundational question. Are there claims that survive as relates to claims against the city of Detroit, given the application of the statute that bars various claims?
Unfortunately not.
All right, so my motion for summary disposition would also result in dismissal of the balance of the case. And I'll sign an order. All right,
Okay,
good day to the two of you. All right.
Your Honor.
All right.
Thank you, Your Honor.
The court will issue its order and you'll get it in the next few days.
okay, thank you.
Thank you, Your Honor. Thank you, Ms. Khan.
All right, now the court addresses case number 20, Ms. Norris and Ms. Troop. Thank you for returning. I thought I had your file still in my hands, but I must have had it put to my clerk. So Ms. Norris, if you give me the last 4 digits on that file, please.
Five.
Yeah, you kind of broke up there, so I got the file now. It's 5325, Madam, reported as Jefferson Capital System versus Sarah Troop. All right, Ms. Norris, why don't you update me if there are any updates for this matter?
Your Honor, unfortunately, we're not able to reach an agreement at this time, so we would just move forward with the scheduled MSD and pretrial.
All right, very well. I'll get the.
Your Honor, I'm sorry. We tried to make a settlement, but it wasn't enough. I mean, I tried, offered, but.
Yeah, and that's all. That's really kind of all that you could do. My thoughts about this, given the longevity, I don't know what the parties discussed in this matter, but I'll tell you what my thoughts would be, just in terms of giving some direction as to what you need to do in this case. It sounds like a $850, $900 case. That's what it sounds like to me. But again, I know it's been going on for a bunch of years. And so with all those years going by, you start talking about interest and stuff. But then there are issues in the case too. And so I don't know what numbers you all talked about. If you were in those numbers, that probably is about what the case should settle. If you're not in those numbers, then I understand why the case was not resolved. So you don't tell me where you are, but that's about where you should be in order to get this case resolved. That's my that's my take on it. Otherwise, what you get is a lot more paperwork about stuff and a whole lot of other stuff going on. And I don't mind dealing with all of that. It's just if you got a case that involves $5,000 or $7,000 or $8,000, then I get it. The claim here is $1,200. But that's not my ultimate call to make. My ultimate call will be in the case. But if you're essentially $300 or $400 apart, then you're probably in the right range of being able to resolve this. That's mine. Okay. So I've given you the new court date. We'll get some stuff out to you in the mail. The motion to dismiss is taken with advisement. The interrogatories will be sent to Ms. Norris. And if you wish, you might want to send, if you prepare some answers to request to admit, you might want to send those to Ms. Norris as well. All right. So good day to you.
Thank you, Your Honor.
All right. Thank you. Good day to you.
Thank you. Bye.
Just one moment. All right, this is case number 21-17-2838. This is Prism Lab LLC versus City of Detroit. The matter is before the court. Looks like set on for a pretrial. The court has received the answer. The matter is properly joined. Your appearance at this time for the plaintiff.
Yes, good morning, Your Honor. Clifford Neubauer, appearing on behalf of plaintiff P70910.
Thank you. And good morning to you, Mr. Neubauer. For the City of Detroit here, your appearance at this time, sir.
Good morning, Your Honor. Joel Ashton, appearing for the city of Detroit, P number 47039.
All right, thank you, Mr. Ashton, and good morning to you as well, sir. All right, so it looks like and the matter is all set up for some discovery process. Has there been any additional disclosures or anything regarding this matter?
Your Honor, we were able to kind of fast track this case by facilitating it recently with some related earlier filed cases. And at this point, we do have a tentative settlement for which we're awaiting final approval from the city.
That sounds about the size of it to you, Mr. Neubauer, as well, sir?
Yes, Your Honor, that's accurate.
So what I'm going to do is I have a order, as Mr. Ashton may know, that will conditionally dismiss the case contingent upon the settlement. And I will issue that order. And of course, if the case for some reason doesn't get finally resolved, then it'll automatically be reinstated. So you'll get such an order from me in the next few days. I wish you well. Good day to the two of you.
Thank you, Judge. You too.
Thank you.
We're not calls case number 21-162-348. This is Tox Testing versus Michigan Automobile Insurance Assigned Claims Facility, City of Detroit, Defendant 2, Defendant 3, Suburban Mobility Authority, SMART. Matter is before the court on the following. Check that. It's before the court after the extension of discovery. Do I have anyone for tox testing? Yeah. Stand by.
Yeah, 2000. How about that? You're filming the wrong one.
Right.
This stuff.
Oh, they made 2000.
Yeah. That was just.
Oh, that's 348.
This is. All right, this is 21-162-348, Michigan First Rehab versus Nationwide Mutual Insurance Company. There was some paperwork from another file that kind of threw me off this front a little bit. All right, your appearance for Michigan First Rehab, please.
Good morning, Your Honor. Connor Cordy, P84485, appearing on behalf of the plaintiff.
All right, thank you, sir. Good morning to you.
Good morning. Good morning.
Nationwide, your appearance, sir.
Nicholas Ackerman, P number 85192, appearing on behalf of Nationwide Mutual Fire Insurance in this matter.
All right, thank you, Mr. Hoffman. Good morning. Good morning to you as well. All right, so Ms. Gloria, I think you wanted to just update on what's going on here. I remember on this case a little bit. Go ahead, sir.
Your Honor, the parties have been engaging in settlement discussions. I know that Brother Counsel's colleague, Mr. Capone, has spoken with his adjuster as of this morning. They have made a counter offer to my client's initial offer to settle. In engaging in further discussions, the parties have agreed, with the court's blessing, of course, to go to case evaluation, and that is the word, Your Honor.
Sounds about right to you at this time, Mr. Hoffman?
Yeah, we were asking this court to send us to case eval.
All right, I will set the matter up for a case evaluation. And I will, I'll set a new control date on this matter. Of course, if you get it resolved in change things there. I think I'm gonna go ahead and set it out for the 23rd of May, May 23rd at 10 o'clock a.m.
Your Honor, do you want me to submit an order?
Yeah, why don't you then, start and submit it to the email address, so that I can go ahead and get that signed. Typically what I issue is something that's along the line of a order for mediation. And I already have an order basically ready for that. And it says mediation or evaluation, and it gives you the option to move forward on both. I could issue that. If you got something a little bit more specific, I'll sign with you.
Okay, I'll prepare the order today, Your Honor. I'll submit it to the email.
All right, and you have the email address, Ms. Lord?
I do not, Your Honor, if I could get it from your clerk.
Very well, that's Latifa, first name Latifah. Latifah, Latifa dot, last name is Hunter, Latifa.Hunter at 36districtcourt.org.
Thank you, Your Honor. I will get the order submitted and I will CC brother counsel to it.
Thank you.
Very well, gentlemen, I wish you well, and then next action date 5/23 at 10 o'clock a.m. And if you could go ahead and put that in your order, Ms. Florida, the next hearing date, just notice that up in your order. You'll get another notice, but that putting that in the order will be helpful as well.
Yes, Your Honor.
Thank you, gentlemen. Good day.
Have a good day, Your Honor.
Thank you all.
You too.